We have an urgent Supreme Court development that every firearm owner across America must pay attention to, particularly those residing in California. This development brings mixed emotions. There's reason for hope, yet profound irritation simmers beneath the surface. Duncan v. Bonta, the landmark case targeting California's sweeping magazine prohibition, encountered yet another hurdle at the nation's highest court. This fresh obstacle suggests we might face an extended wait, potentially several years, before reaching resolution, assuming the justices agree to review it at all. Yet, what elevates this situation's importance is Duncan's company in legal limbo. Multiple magazine restriction challenges and assault weapon prohibition cases now share an identical conference schedule next month. February 20th stands poised to become a watershed moment for Second Amendment jurisprudence in modern memory. So let's dissect precisely what transpired with Duncan, examine why the court's recent maneuver raises red flags, explore the fallout should they reject this petition outright, and identify which companion cases might reshape the landscape for firearm enthusiasts across the country. Allow me to provide comprehensive background on this litigation's current posture, because newcomers to this saga deserve appreciation for its extraordinary duration. Duncan against Bonta has languished before the Supreme Court since August 2024, approaching half a year of anticipation. And for California's gun-owning population, these months brought relentless tension, checking repeatedly whether the court committed to hearing this dispute. Permit me to trace our path to this juncture. During March 2024, the Ninth Circuit's full appellate bench delivered a crushing determination. They concluded that California's prohibition against standard capacity magazines withstands constitutional scrutiny. I'll quote their precise holding, as the terminology carries weight. The en banc panel determined that Golden State legislation forbidding possession of standard capacity magazines aligns with Second Amendment guarantees. They reversed the trial judge's opposing finding and directed entry of judgment favoring California's Attorney General. That decision, if it had taken immediate effect, would have obliterated Second Amendment protections for countless Californians. Responsible firearm owners possessing standard capacity magazines would have become felons overnight. But here's the critical part. That same Ninth Circuit en banc panel stayed execution of their own judgment. Why? Because they knew the plaintiffs, Virginia Duncan alongside the California Rifle and Pistol Association, would seek Supreme Court intervention. And they did exactly that in August 2024. That stay is the only legal shield preventing California's magazine prohibition from taking effect right now. The fate of magazine ownership throughout California hinges entirely on whether the Supreme Court elects to hear this case and reverse the Ninth Circuit's ruling. Now, for those unfamiliar with how the Supreme Court operates, let me explain what's happening behind the scenes. The court uses conferences to decide which cases it will hear. All 9 justices meet privately, review petitions, debate them, and vote on whether to grant certiorari. It takes only 4 justices to agree. Just 4. Duncan v. Bonta has appeared at conference 6 times already. 6. And this is the second time this case has reached the Supreme Court. The justices know it well. They understand the record, the arguments, and the constitutional stakes. Every single time Duncan has appeared, the court has neither accepted nor rejected it. They've relisted it. That's legal limbo. And here's the troubling development. Duncan appeared on the January 26th conference calendar. California gun owners waited anxiously for the January 29th orders list. When it was released, Duncan was nowhere to be found. Not granted, not denied, just delayed again. But this delay is different. That's why it matters. According to the Supreme Court's calendar, there is no additional conference until February 20th. That's nearly a month, and that delay carries serious consequences. By pushing Duncan to February 20th, the court has all but guaranteed that even if cert is granted, the case will not be heard during the current term. The current Supreme Court term ends in June 2025. Cases accepted this late are typically scheduled for argument the following term, starting October 2025 at the earliest, and realistically, arguments could slip into 2026, with a final ruling potentially not arriving until 2027. Think about that. This case has been active for years. The en banc opinion came down in March 2024. The cert petition was filed in August 2024, and now we may be looking at final resolution in 2026 or 2027. That's years of Californians living under unconstitutional uncertainty. Years where rights are acknowledged but withheld. Now, if there is any consolation, and it's minimal, it's this. The Ninth Circuit's stay remains in effect. That means California's magazine ban is still unenforceable for at least another month, and likely longer. Freedom Week magazines remain protected. For those unfamiliar, Freedom Week was the brief period in 2019 when a federal judge blocked enforcement of California's magazine ban, allowing lawful purchases. Hundreds of thousands of Californians acquired magazines during that window. As long as the stay exists, possession remains lawful. But the moment the Supreme Court denies cert, that protection disappears. And that brings us to the nightmare scenario. What happens if the Supreme Court rejects Duncan versus Bonta? First, the ban does not activate instantly. The denial would be transmitted to the Ninth Circuit, which would then issue its mandate. That mandate is what makes the prior opinion final and enforceable. Once issued, California's magazine ban goes live. The Ninth Circuit could allow compliance time. But given California's history, I wouldn't expect mercy. Enforcement could begin immediately. Let me read directly from the statute. Senate Bill 1446. It states that any person possessing a standard capacity magazine commits an infraction, acquisition date notwithstanding. That means it doesn't matter when you bought it. Freedom Week. 20 years ago, legally or not. Possession alone triggers liability. Penalties range from $100 for the first violation to $500 for subsequent violations, and each magazine can count separately. Now, here's the part that should enrage every American. The law exempts law enforcement officers, government agents, and their security. California has created two classes of citizens, one with full Second Amendment rights and one without. That is exactly the kind of constitutional violation the Supreme Court exists to stop, and rejecting Duncan would effectively bless it. This fight has now lasted nearly a decade. SB 1446 passed in 2016. Someone who is 21 today was 12 when it became law. An entire generation has grown up under unconstitutional restriction. That normalization is dangerous. That's why February 20th matters so much. Duncan is not alone. The Supreme Court will also consider NAGR versus Lamont from Connecticut, challenging both magazine and rifle bans. Multiple cases. One conference. February 23rd will reveal the outcome. The court could grant one case, several cases, or none. Any outcome reshapes the national landscape. If cert is granted, resolution takes time. If cert is denied, enforcement follows swiftly. This is not just about magazines. It's about whether constitutional rights mean the same thing in every state. February 23rd may answer that question. I'll be here when it does. If this breakdown helped, make sure you subscribe to Weapons Law Advisor, and don't forget to like and comment on the video to help us reach our amazing milestone of 10,000 subscribers. Every single subscriber matters. Your support is what makes this journey possible.